Silent. I'll give it to you once I sign it. Board, all rise. Hear. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning and welcome to the Appeals Court. I'm Judge Milkey. To my right is Judge Neyman. To my left is Judge Smyth. And we are your panel on 4 of the 5 cases we are hearing this morning. There's a panel change for the 5th case, and the 6th case is off the list. I want to assure everyone that we have read the briefs and the record, so we are familiar with both your arguments and the facts. And I say that because 15 minutes per side is generally not a lot of time, so we urge you, if at all possible, to cut to the chase. And we will assist you in that effort through questions. That said, if you feel you have used your time and have nothing more to say, there's no shame in sitting down. As one of our ex-colleagues used to say, if you hit a home run, there's no reason to run the bases twice. And with that, I will call the first case of the day, which is a SORB matter, 2021 P1083, John Vo, number 6615 versus Sex Offender Registry Board. And I will remind the parties, of course, that the case is impounded, so please, no names of the petitioner or any victims.
Good morning. Excuse me. May it please the court. Attorney Xiomara Hernandez for the plaintiff appellant John Vo. I'm here today requesting that this court lower my client's classification level from a level 2 to a level 1 or remand the case back to the board for another classification hearing. I would assert that the hearing examiner erred I'm sorry, I thought I heard something. The hearing examiner erred by finding that in 1989, my client raped the victim in that case.
You focus in part on whether or not the evidence supports attempted rape versus rape. For these purposes, why is that relevant? I think we can all agree it's a great thing that the victim escaped, but...
Well, as you know, the hearing examiner found that my client poses a moderate risk of reoffending, and a reason for finding that was because in '89 and in 1997, he asserts that my client was guilty of rape. I would argue that my client was guilty of rape, but for the 1997 incident, not for the 1989 incident. In 1989, he did not plead guilty to rape. He pled guilty to assault with intent to rape, and also...
But again, why does it matter? If the issue is the risk of recidivism,
well, that was...
If it's a failed attempt, it's still an attempted rape, So,
because the hearing examiner found that the reason why my client poses a moderate risk of reoffending is because he raped 2 individual victims. And I would assert to you, there's not sufficient information in the evidence to indicate that he actually raped the person in 1989. So that would be my assertion regarding that. Additionally, the hearing examiner erred by finding that my client, that risk mitigating factor 32, sex offender.
Actually, before you move on the
Yes.
first point, you're aware there is evidence in the record. You cite Exhibit 119, but you're aware there's another report of the officer who interviewed the complainant, the named victim, and she stated, got on top of her and did put his penis into her vagina.
I mean, even that was a little bit, that's on page 123 of volume 1. Even that assertion was a little bit unclear because the officer goes on to indicate that he did not finish, which I'm not sure exactly what that means. The way I interpret it.
Isn't starting enough?
No, I mean, my client, what he did was horrendous, for sure. And, the hearing examiner is proper to take what he did into consideration. But what I'm saying is rape is very different from attempted rape.
why?
Because
For these purposes, not for sentencing purposes, but in terms of figuring out the risk of recidivism and the potential danger, why does it matter?
Because there is in terms of the board, there is a huge difference. They look at it very differently. Raping is more obviously intrusive than attempting to rape. And again, what my client did, I'm not excusing what my client did. What I'm saying is there's not sufficient evidence in the record to indicate that it was in fact rape. And this hearing examiner found that my client raped 2 different people in 2 different years, and I'm just saying that there just wasn't enough. And I get that the rules of evidence don't apply to these hearings, but at least there has to be reliable, reasonable evidence that the hearing examiner relied upon. Again, my client did not plead guilty to rape. The charge of rape was actually dismissed by the prosecutor. And it's just unclear, if you read the record, it's just unclear if he actually did rape this young lady. And again, what he did to her was horrendous, and I'm not excusing it. So that there's that error, and I also would assert there's the error of not giving full weight to risk mitigating factor 32, which is sex offender treatment. Here, the hearing examiner found on page 38 of the Record Appendix Volume 1 that the reason why he did not give this factor full weight is because there's people in his family, his sister and his long-term girlfriend, who indicate that he possibly did not commit these offenses. But if you read the regulation, the denial aspect of the regulation applies to the offender himself, not whether or not his family members are in denial. So I would assert that this wasn't a sufficient reason to not give this risk mitigating factor full weight. And I'm sure you read the record and you'll see that he does have, he was involved in sex offender treatment. He was very active in it and consistent. In addition to that, I would argue that the hearing examiner erred by failing to give full credit to risk mitigating factor 33. And one reason why he used for not giving that factor full credit was because not everyone expressed knowledge, the people who wrote letters of support, not all of them expressed knowledge that they were aware of his sex offenses. But yet, on page 39 of Volume 1, the hearing examiner also writes, Vo has a stable network of support, including family members and friends, all of whom are aware of his offense. So one part of the decision, he writes that not everyone's aware of the offense. In another part of the decision, he writes that everyone is aware of the offense. And I would assert there was sufficient evidence in the record indicating that he does have stable home situation and support
How
system.
consequential do you think that was, where the hearing examiner did accept a level 2 classification, notwithstanding the fairly egregious facts, be it a rape or an intended rape?
That alone would not have been consequential, but I think that combined with the other errors that I believe he made, including the finding that it was rape and also not giving full credit for sex offender treatment. And I would assert, just in totality of the circumstances, all the facts involved in this case, that my client does not pose a moderate risk of reoffending. As you know, his index crimes were committed multiple decades ago. One was committed in 1989, another in 1997. He's been free in the community for over 20 years and has not reoffended. He does have a stable home situation where he's been living with his girlfriend for 7 years and also lives with his son. He does have stable income. He was working prior to getting SSI, and he is getting stable income now. And he was seeing a therapist for many years, Dr. Ciampi. And that doctor has known him, I believe, for 10 years or so, and he provided a letter in 2019 indicating that there's no evidence that my client will be at risk of reoffending. Also, my client's 54 years old. He was much younger. He was in his 30s when he committed these, horrendous crimes. Again, but he's 54, and if the regulation number 30, the older a person gets, the less likely they are to reoffend. So that's a factor that the hearing examiner did give him credit for, not full credit because one of the victims was young, but he is getting credit for that. And I would assert that because of these reasons, that my client does not pose a medium risk, a moderate risk of reoffending. In fact, he poses a small risk of reoffending. Again, many years ago, love and support of his family, stable income, stable housing, and for all these reasons, I would ask that this court either lower my client's classification level to a level 1 or remand the case back to the board. And if there are no further questions?
Yes. If we were to remand to the court for a reclassification hearing, could the hearing examiner impose any level of classification at the rehearing, whether it was to reduce to 1 or to raise it to a 3?
Could the hearing examiner raise it to a 3? Is that what you're asking?
Upon further, yes, if there would be,
So
presumably if we were to remand, it would be a de novo hearing for reclassification.
So there's two different ways that the board has approached these remands. Sometimes they'll just correct the mistakes that the hearing examiner made and reissue a decision without offering another hearing. And in that case, I would argue that they wouldn't be able to put it at a 3. They would just have to look at the evidence and look at what they had to fix and decide whether or not, my client should be at 1. If they were to have another hearing, I guess in theory, they would be able to increase my client's classification level if there was other things that happened since the hearing, which was in 2020. So if, let's say, he did commit another sex offense or, was violent or whatever, they could possibly increase it if they had another hearing.
Thank you very much, counsel. We'll hear from Mr. Chennai.
If it pleases the court,
It's
Your
been
Honor.
too long.
If it pleases the court, Your Honor, David Chennai for the board. Getting back to Justice Neyman's question, unless this court orders a new hearing, the board will amend the decision to correct whatever mistakes or consider the mistakes that the court wishes them to look at. In another hearing, unless this individual has committed some other offense since his 2017 offense, I don't see them raising his classification. In theory, they could, but generally they would have to find he's continually doing something more because it's based on current risk and danger.
What if the hearing officer had left, and so there has to be a new hearing in front of a new hearing examiner? Would that hearing examiner be bound by the level 2?
Well, no hearing examiner, even the original one, would be bound by it, but I think that my experience with the board is, because you're looking at current risk and danger, and this was from 2020, so 3 years have gone by, so it would be harder for them to say he's now a 3 when nothing's happened since 2017. So unless he commits some other offense or does something that indicates antisocial or lawless behavior from 2017 to the remand, the board I would hazard to guess, would not be raising his classification.
You're saying that's a matter of practice, though. It's not, for example, akin to a remand for resentencing in a criminal case where the sentencing judge cannot go beyond the original sentence.
Correct.
It's legally conceivable that a higher classification could occur, but what you're telling us is that's just not the practice of the board.
Well, it's like years ago I had a civil rights violation case in front of Judge Barton. And Judge Barton said in a jury waive trial, right before he said, you can't prove civil rights violations. And when the trial ended, he goes, I stand corrected, you can. And so my client was very stunned at that I had gone forward with the trial. But, you know, that's kind of analogous to this, is that it could happen. I'd be stunned if it did happen.
Shocked if it did, okay.
And, you know, really what this comes down to is in 2020, the issue was current risk and danger. The old sex offenses are really the basis of the danger and risk he poses should he reoffend. But then you look at positive strides, what's happened in the interim. And unfortunately for this individual, from 2004, when he was classified as a level 3, he still committed crimes. He had a possession of Class B, which was continued without a finding. I think he had a sexual conduct for a fee. He had a failure to register as a sex offender. He got 30 days. But more importantly, he had the 2017 assault and battery against his girlfriend, who was pregnant at the time. And that's a big flag for the board, because it shows not only antisocial behavior, it shows lawlessness, and the ability to act with no regard to the safety of others, and hostility toward women. And again, you tie up the 2017 case with his 2000 assault and battery against another ex-girlfriend, another girlfriend at that time. You put those two together, and he shows a pattern of hostility. There's some years between them, but he still shows it. As for the, interestingly enough, the third sex offense, which is the most horrendous of them, in 1998, he got a 5 to 7. Within a very short time of his release, he committed the sex offense against the girl, the 14-year-old girl, which was a violent sex offense. So he does have, beginning the hearing, a high level in danger and a high risk because of the sex offending behavior, because of his criminal record prior to that. But again, the hearing examiner starts looking at the positive strides. He did participate in sex offender treatment. He didn't complete the treatment, so he doesn't get full credit for that. He had aged to 53. He didn't get full credit for that, but he did age enough where he got some credit for that. The hearing examiner gave some credit for his support network, but was concerned because nobody in the support network talked about the guidance and support they would give to help him for rehabilitation and to prevent him from reoffending. And two of his most closest people, his mother and his sister and his fiance, both said he was wrongly convicted of the crimes. So, but the hearing examiner still credited him somewhat for that and gave full credit for his current stability. And that's where we get to the level 2. Looking at this as a whole, the whole picture, in 2020, I can't see a hearing examiner ever making him a 1 because of the continued, not only the continued criminal behavior, but that 2017 case, it's like a giant red flag for SORB regulations. And I think I've covered all of these issues fairly well in my brief, so if there's any, unless there's any further questions, I'd be more than happy to rest on my brief.
Hearing none, thank you both very much. The case is submitted.
Thank you.
Our next case is Commonwealth v. DIXON, 2020 P. 1190.
Good morning.
Morning.
Estera Halperin, for Mr. Dixon. May it please the court? I raised one issue in this case. And the issue is whether the judge, by telling the jury that they must follow the law as the judge gives them, deprive the jury of the power to vote their conscience. Now, I would say that whatever the Commonwealth addresses in their brief will basically agree with this, that there was no objection. In fact, the defense lawyer had a strategy to concede possession with intent to distribute the marijuana.
Can I just jump in? Your brief is one of the most interesting briefs I've read in a long time, and I frankly learned a lot about the law in other states and the law in olden times. What I didn't see there is an argument that the lack of instruction here was an error under mass law, as very clearly stated in any number of cases. Why should we, especially as an intermediate appellate court, revisit this issue?
Your Honor, I appreciate your kind words. So one of the ways that the counsel could have done this, of course, when raising the issue in the first place with the judge, but I understand that the court feels bound by the decision of the SJC. And I don't see necessarily how the issue, that is a very important issue actually, especially that it has that history that people actually don't know much about. And it reflects the idea that you must follow the law. You sit on a jury, you decide.
Okay, but breaking the question down, we cannot disobey the SJC. That's sort of foundational. Where the SJC has clearly spoken on this issue, do we even have the power to come up with a different rule?
Well, how would the case necessarily get to the SJC?
So are you saying you raised this simply as a way station to preserve your argument, to try to...
Frankly, I wasn't thinking about it when I did this, did this brief, because I also had to learn about the power and how the other states see this and how the history evolves. But this issue of depriving a juror, telling the juror, you must judge this person, this defendant, but you deprive the juror of actually being true to their conscience, is a very serious issue that should be addressed. Now, it is addressed in numerous and voluminous articles by historians of the law, both in England and in the United States. And doing justice in individual case is what we ask the jurors to do. But yet we deprive them of their ability to do justice and to bring the law and justice more closely together. Now, I think the concern that I have is that there may be some juror that knows about their power and believes in that power. So that means that some jurors may actually act on it, and another jurors would not. Another jury would not.
I'm sorry to interrupt. Is your argument grounded in the federal Constitution or the state Constitution?
It's grounded basically in the history, and the history is that for a number of decades, the jurors understood that they had the power to rule on the law.
So it sounds like you're making the argument that the basis is common law, not constitutional. Is that correct?
Well, it's constitutional in the sense that if the jurors should have the right to, not just the power, but should be informed that they could act on their power.
So if it's constitutional, I go back to my question. Are you basing this on the federal constitution or the state constitution?
Only on the federal constitution as it relates to structural error.
So I suppose that answers Justice Milkey's question in terms of how this case could get, how we could make that ruling. If we are addressing an issue that the United States Supreme Court, for example, had weighed in on,
It waited
and the
on,
Supreme Judicial Court had not ruled on it under federal law, that would be a way for us to decide the case, I suppose.
well, I agree that that's a hurdle. I mean, I agree. But I think that the Commonwealth's argument just doesn't address the issue, the really important issue in this case.
So putting all of this aside, whether or not we even had the authority to look at this issue, why should we do it in this case where at trial there was a very conscious strategic choice made, unusual and from all appearances highly successful, where counsel said, my client's guilty of this, but not guilty of that? Why should we then give a second bite of the apple and say, no, even as to what counsel said he was guilty of, he gets another bite at the apple?
Well, one reason is the nature of the offense, that this was at the time where the public, the conscience of the public, voting directly on the issue of possession of marijuana was definitely going in opposite direction than the law was, as decided by the legislature. So in 2016, they passed a law. They voted, the people voted to allow possession of marijuana. So there was a sort of a dissonance between the public and the legislature. So possession of marijuana wasn't at that point something that
But this
the
was
jury
not,
could have actually, if informed about their power, could have actually returned a not guilty. We don't know. But as your Honor said, lawyers don't know the history, and they actually never question when the judge says, you must follow the law. In this case, the judge also said that I find actually unusual, a little bit unusual for the judge to say that you shouldn't worry about, don't concern yourself with the sentence. That's sort of saying, well, how can you tell the jurors not to be concerned about the consequences of the action? But the judge's instructions were what lawyers accepted. And it's really about educating the public and the lawyers. And then we will have a judgment of the jury that both is consistent with the law and individual conscience of the jury in individual cases. I would ask the court to reverse, and thank you. If no question.
thank you very much, counsel. We'll hear from Mr. Stark. If you could tilt the mic, it's directional. Thank you.
Good morning, Your Honors, and may it please the Court. My name is Trevor Larned Stark, Appeals Intern at the Suffolk County District Attorney's Office, and I'm appearing by motion before this Court alongside Assistant District Attorney Catherine Sherman on behalf of the Commonwealth. The Commonwealth asked this Court to affirm the defendant's 2018 conviction for possession of marijuana with the intent to distribute, because the jury instructions were proper and the jury was not divested from the ability to vote their conscience. The defendant argues that the trial judge committed structural error and challenges 4 of the jury instructions in particular. The first 3 of those instructions deal with the role of the judge as the judge of the law, and the 4th instructed jurors not to consider sentencing in reaching their verdict. Each of those instructions accurately explains the respective roles of the judge and the jury, and they mirrored previously upheld instructions and the model instructions. As this court noted, the Supreme Judicial Court has repeatedly held, including in Diachenko and Rakes, that where instructions are accurate statements of the relevant law, giving them is not error.
Have we ever explicitly addressed the issue of jury nullification?
Yes, Your Honor. Several times, actually. Turning first to the instruction that the court is the judge of the law.
What's the lead case in Massachusetts on jury nullification, the right for a jury to nullify?
Commonwealth v. Kirwan, 448 Mass. 304, that's from 2007. The SJC said that jury nullification is inconsistent with the jury's duty to return a guilty verdict of the highest crime proved beyond a reasonable doubt. And the SJC also addressed this in Commonwealth v. Hebert, saying that although it is improper to disregard the law, it still remains within their power to do so. And that's the distinction we're trying to draw, is the ability of the jury to acquit conscientiously, but that is not a right that jurors have.
So how does a jury, in the face of that instruction by the judge that you must apply the law as I give it, which is another way of saying there's no right to jury nullification, how does a jury have the power? Does it just stem from the fact that whatever a jury does is sacrosanct and we don't enter jury deliberations, or is there some other rationale?
Yes, Your Honor, that jury nullification is, in essence, a byproduct of the privilege we give to jury deliberations. We're not going to intrude into the jury room to ask about the deliberations. We're not going to go through whether each element of or whether individual facts of the crime were proven. We will take the general verdict, which says guilty or not guilty, and we will not intrude into their deliberations or their rationale for reaching that. So if a jury is nullifying, we would never know.
And even if we did, it doesn't matter because jeopardy's attached.
Exactly. And because
So, go ahead.
No, you seem to suggest in your brief that any kind of special verdict is improper. Is that right?
No, Your Honor, just simply that the jury has the right to give the general verdict, and that in doing so, we are not going to look into the individual, the facts that have been proven. We're not going to ask why the jury reached their verdict.
No, but say the prosecutor and defense counsel agree that, we're not going to have them find facts, but in a particular case, we want it broken up into 2 pieces, not just guilty or not guilty. Is that doable under state law?
My understanding is yes, that would still be permissible, Your Honor, as long as the judge is merely inquiring as to whether each of those elements has been met, rather than getting at the reasons why jurors have reached those, or have reached that result.
So, otherwise stated, special verdict forms special verdict forms may be allowed in criminal cases, correct?
That's my understanding, Your Honor, yes. Okay. Second, just to address the nullification, the Commonwealth just argues that the defendants argued that the jurors were divested from the ability to acquit here, and that is belied by the evidence on the record and the fact that the jury did find the defendant not guilty of 2 of the 3 charged offenses here. Pending any other questions from the court? Okay. The Commonwealth rests on the brief, and I'd like to thank you for allowing me to appear.
Thank you both very much. The case is submitted. And welcome to the world of appellate advocacy. Our third case of the morning is 2022 P 652, Gurney versus Sykes.
May it please the Court, my name is Seth Roman from Orleans, Massachusetts. I represent the appellants Bernard G. Sykes and Palm Beach Yachting Incorporated. Unfortunately, I also represented them at the trial court level. In this case, the issue before the court is whether the trial judge abused his discretion by denying my client's motion for extension of time for filing a notice of appeal. The circumstances of this case are outlined in the brief, but briefly, the judgment in this case issued on March 10th of last year. Any notice of appeal was to have been filed on or before April 11th. On April 6th, counsel for the defendant, that's me, became sick at work and I was required to return home early. On April 7th, I tested positive for COVID-19, remained in quarantine at home in my basement until April 12th, in accordance with guidelines that existed at that time.
Your affidavit contains all of these facts. I mean, the affidavit that you filed at the trial level. It is understandable during COVID that you would be quarantined. What the affidavit does not state is an inability to still comply with the deadline or lack of knowledge with the deadline. So we don't know, nor did the judge, for example, whether or not you were aware of the deadline but couldn't do anything about it. You were unaware of the deadline, whether you were in bed with a 104 fever and simply could not do anything, in which case that might present an emergency situation. The affidavit is silent, for example, as to whether or not you had access to a home computer or a telephone and could have contacted someone at your firm to file this for you, or could have contacted the clerk's office. I think that's where the judge struggled with this. And if those facts existed after the judge denied the motion, you certainly could have also filed a motion for reconsideration, filling in the details of that. So it begs two questions. The first is, why did you not file a motion for reconsideration? But before that question, I think you need to explain to us why there are those gaps in the affidavit.
Sure. The record is what it is, first of all. And I'd say that it would be a lie if I were to take the position that I was physically unable under any circumstance to place a phone call to somebody from my office who could have taken my place or contacted the court or done something like that.
We respect and appreciate your candor in that regard. Thank you.
So it's what I'd state, though, is that it's not an impossibility standard. It's an excusable neglect standard. And under the judge's decision, the trial court's decision, there were two kind of primary errors that I focused on. One, which I won't focus on as much today, is that the judge seemed to take the position that if it's a matter of attorney neglect or an attorney's oversight, then that is an important factor to be used in making this decision. I agree with that position. However, the judge seemed to suggest that he should not exercise his discretion if the attorney is making the mistake rather than the appellant, the party himself. And the case law actually says otherwise. Generally speaking, if an attorney is the one making a mistake, the party should not be punished for that mistake. There's a general judicial reluctance to charge a party with the errors or omissions of his legal representatives as opposed to his own errors and omissions. And the court is supposed to consider whether, if the errors and omissions were by the attorney, whether there was a deliberate flouting of the rules or strategic disregard of procedural requirements in the case, rather than simply that a mistake was made. Now, under the circumstances, we're talking about a one-day delay. It was literally one day after the appeal deadline was filed that the motion was served. And there's no dispute that the correct procedure, that is Rule 4C, under Rule 4C was followed. But more importantly, the judge in his decision indicates that the reason that the motion is being denied is that counsel could have filed the motion 10 days after the judgment entered, or 15 days after the judgment entered, or 20 days after the judgment entered. And specifically says, here judgment entered on March 10th, 2022, and according to counsel's affidavit, it was April 6, 2022 that counsel fell ill and therefore did not file a notice of appeal within the time allowed. As the plaintiff's opposition points out, there was ample time to do so prior to falling ill. That's the only factor that the judge cites in his opinion, that it could have been done before counsel fell ill, not that it could have been filed by somebody else while counsel was ill. Simply that there was enough time beforehand for it to be filed. And while I would agree that that may be one factor to be considered in general, it sets a very dangerous precedent, and it's susceptible to arbitrary application. The rule is 30 days. If that rule is exceeded and the court says it could have been done before the 30-day deadline, that's not a factor that should be considered by the court, or at least relied upon by the court.
Counsel, you didn't address the merits of any appeal in your brief. Generally speaking, we have an interest in saying that meritorious appeals are not thrown out on technicalities. We also have an interest in not allowing frivolous appeals go forward regardless. I know you haven't briefed the merits, but I've read Judge Gildea's summary judgment ruling. You chose to seek to appeal. You must have a sense of what your strongest argument would be in any such appeal. What would it be?
Sure, it's a very narrow appeal, Your Honor. This isn't a situation where there'd be an argument that Judge Gildea's ruling was in any way deficient. It's simply a matter of Judge Perino, who issued the judgment ultimately upon motion following summary judgment on liability, that he miscalculated the damage amount. Specifically, the gist of the damages was that my client obtained approximately $800,000 from this trust that he was trustee of. And he then misused that money by spending it on boats that he was refurbishing through this company, Palm Beach Yachting. He called it an investment.
So if I could just rephrase what you just said, the error you would be arguing is not in ruling that your client was liable on summary judgment. It was in translating that into the judgment itself that had specific damages, et cetera.
Correct. So my client was found liable on multiple counts. I mean, there was a fiduciary breach claim, there was a constructive, I'm sorry, I apologize. Many counts he was found liable on. Two of
the rest were dismissed.
And the rest were dismissed, correct. Two of the counts were basically that he converted funds by taking them out of not just the trust in Palm Beach Yachting, but using other companies that he was involved with. Those converted funds, I would suggest, were on appeal. The argument would be that those converted funds were part of this $800,000 that he had taken initially from the trust, rather than separate line items of damages. So although certain aspects of damage resulted from certain causes of action that were brought, overall the damages were all subsumed by this $800,000 figure. And we're talking about, it's simply one figure of $25,000 that's entered into the judgment, and another figure of $27,400. So we're talking about just over $50,000.
So you're not, in the underlying case, you're not contesting liability, you're contesting the calculation of damages, which it seems to say that the judge somehow maybe double counted in some area to the tune of a total of $52,000.
That's correct.
So at a minimum, you would agree that your client is on the hook for $748,000 plus attorney's fees, interest, et cetera?
Yes. Unless there are any questions, thank you.
Thank you very much. We'll hear from Ms. Hirsch.
Good morning, and may it please the court. My name is Jillian Hirsch, and I represent appellees Lorraine Gurney, Austin Gurney, and Amil Weinstock in his capacity as trustee of the First Amendment and restatement to the Lorraine R. and Austin W. Gurney Trust dated May 2016. The trial court in this case did not abuse its discretion by denying appellant's motion for an extension of time to file a notice of appeal where the appellant's failure to timely file the notice did not constitute excusable
No, counsel,
neglect.
the only reason the judge gave was, and I'm paraphrasing slightly, counsel could have filed it in the 25 days before he got sick. Focusing on that narrow reason, isn't that just wrong as a matter of law, that that's beside the point?
It is not beside the point, Your Honor. Excusable neglect is a very demanding standard, and the case law in Massachusetts reflects that fact. To suggest that excusable neglect was present here because counsel for appellants
No, but
merely
I'm asking you to
forgot.
focus on the first 25 days.
Yes, Your Honor. Essentially, for the first 25 days, counsel for appellants forgot to file the notice of appeal, and then claims that his failure to file the notice of appeal was excused by the last 5 days of that 30-day period. In fact, Your Honor, I believe, and this is not in the record, but I believe the only reason that appellant's counsel realized that deadline had passed was because we promptly filed with the court a request at an execution issue. I served Mr. Roman with that at 3 o'clock on April 12th.
Is this in the record?
The
current record
timing,
before us.
It is not, Your Honor. So I do believe that the 25-day lapse is important, but it's not the only.
Let's assume we disagree with that.
Yes.
And the case hinges on what's in the affidavit regarding those final 5 days. What's your argument then?
My argument would be what Your Honor mentioned at the outset of this argument, which is Mr. Roman in his affidavit fails to state, number one, that he was unable to file the notice of appeal once he was quarantined at home. As you mentioned, Your Honor, he could have reached a computer. He could have made a phone call. He could have done it himself. It's a very simple one-page notice. He could have asked any one of the 13 attorneys at his firm to do it for him. It was easy to get that done, and he didn't do it.
But that wasn't the grounds on which the judge relied. And typically, we're reviewing a question of abuse of discretion, and the grounds on which the judge relied are erroneous, we send it back. Because we don't know if the judge would have come up with a different result. It's not that, we decide that the judge could have used his discretion in a certain way. It's whether he did. And how do we answer that question if the only grounds he cited may be erroneous?
Your Honor, I would point out that this court, in the first instance, is assessing whether or not the trial court judge abused his discretion. There's really two levels of discretion here. Whether the trial court judge abused his discretion. And the appeals court has stated that that means you need to determine that the trial court judge that his decision-making was exercised in a fashion that could be characterized by arbitrary determination, capricious disposition, whimsical thinking, or idiosyncratic choice. That's a very high standard. Even if, however, the trial court judge had determined there was excusable neglect, there's still another level of discretion that the trial court could have exercised. Rule 4C says that upon a showing of excusable neglect, the lower court may extend the time for filing a notice of appeal. So there's another level at which the trial court could have said, even if it had determined there was excusable neglect, I'm still not going to extend this deadline, because there is a purpose for Rule 4, and that is to put the parties on notice, and in particular the appellees here, that the case is over, that they can move on, that they cannot be beholden to the burdens that are placed on them by this appeal. Now here, we filed this case now nearly 5 years ago, and we did so because my clients suffered significant financial damage as a result of the appellants here. During the pendency of this lawsuit, my client, LORAINE Gurney, has become significantly more ill, and the trust funds are dwindling. And she was finally able to...
Is this in the record?
This is in the record. And she was finally able to obtain this judgment for $1.5 million, $1 million of which is damages and in excess of $400,000, which is interest. She should be able to access those funds so she can pay for her own care. She has around-the-clock care, and it's very difficult to pay for that without access to these funds. So if this appeal allows the appellants to move forward with an underlying appeal of the judgment, which has been stated here today would really only address $50,000 of a $1 million damages claim. This case will be tied up for a very long time, and my clients will not be able to access those funds that everybody agrees should be there for their benefit.
You agree with your brother's representation that the amount in controversy on appeal is approximately $52,000 out of the $1.5 million judgment?
I do, yes, counsel has represented that to me in the past, that if he were able to proceed with the underlying appeal, that's what it would be.
It's certainly not the role of this court to tell the parties what to do, but there is time. This panel has not made up its mind, I can assure you, none of us, as to what direction we're going with this. Unless and until we issue our decision, there is time for counsel to discuss, perhaps meeting somewhere in the middle and resolving this short of, with predictability of outcome and a guarantee, as opposed to the unpredictability with which the court will decide this case.
We have been engaged in those discussions for a very long time, and unfortunately, they haven't come to fruition.
But we're at an inflection point where we either allow the appeal to go forward or we don't. And we will do our job in sorting through these issues, but as Judge Neyman is suggesting, it would probably behoove the parties to keep those talks alive.
We agree with you, Your Honor, and if we could get some commitment from the appellant, that would happen. It's not for lack of our trying.
And I'm not as deeply versed in the merits as I might be in other circumstances, but it strikes me that there also might potentially be a middle ground in terms of moving assets over without resolving any appeal. So letting a limited appeal go forward while satisfying your client's needs to see what she's entitled to in the interim. So I don't mean to tell the parties where they should go, but I just urge you to be creative.
We appreciate your guidance. There's one last point I would just like to make, and that is with respect to counsel's suggestion that ordinarily parties are not bound by the mistakes or inaction of their counsel. And I would just like to point the court to the Commonwealth versus Trussell case cited in the papers. That is wrong as a matter of law. In that case, the appeals court said in civil cases, the parties ordinarily are bound by the actions or inactions of counsel. And in fact, all of the cases that are cited in our papers and in the court's decision that deal with this precise issue, counsel's mistake leading to a failure to timely file a notice of appeal, are instances where the parties are bound by the consequences of their counsel's inaction or mistakes.
Thank you both very much. Interesting little chestnut. The case is submitted. We're going to hear one more case before we break for a panel change, and that is 2022 P415, Cass versus, I believe it's BACHE, but I am willing to be corrected and apologize if I need to be. Mr. Cass.
Good morning, Your Honor. May it please the court. My name is Stephen Cass, and I'm representing myself in this matter. I'm requesting the court to reverse the Superior Court decision. And there are 3 incorrect decisions made by the Barnstable Superior Court judges, which I'd like to address.
Could we just address first your argument that you should be entitled to some amount of leniency because you're representing yourself?
Sure.
And my question isn't whether that proposition is supported by the law, it's what exactly are you arguing in terms, operationally?
Sure.
You're not arguing that the 3-year statute of limitations does not apply. So what is it, on what point do you say we should be lenient?
In drafting the complaint pro se, I included far too much information for fear of leaving things out, which I believe confused the judge. And so I think in terms of being lenient about how I crafted the complaint, it was not as concise, and I think it provided information that was irrelevant.
But you're not saying the information isn't true. You, in fact, allege it is true. So
Yes.
Why shouldn't we take that into account?
I'm asking the court do because it was, again, trying myself. I'm simply included extraneous information that, like I said, I believe confused the judges in making their decision.
I mean, whether or not the judge was confused really doesn't turn on whether you're pro se or not.
Okay, fair. So the 3 decisions, the first was the statute of limitations, and that was the main one. And the case hinges on confidential communications, emails and police reports.
I want to drill down on what you mean by confidential, because all, or at least mostly, the emails we're talking about are emails between people with school board officials. And those are not confidential. They may be unknown at various points, but they're hardly confidential.
They're confidential until I received them, and I tried my darndest to get access to them, and that was refused over and over, as I stated in the record. So to me, they were confidential because...
Were there any public records requests prior to February of 2018?
Prior to February of 2018, there were not, because those documents should have been provided as part of my lawsuit, my whistleblower lawsuit. So there was no reason to have public records requests because the documents pertaining to Scott Parsegian and his communications with the football parents, those documents should have been provided with that package of information, and they were not.
But none of the current, defendants in the case before us were a party to the federal court case, correct?
They were not. In fact, I didn't learn of what they had done and what they were doing until I received that first packet of information on February 28, 2018. After that, I made requests of counsel to provide more Scott Parsegian emails. They didn't. I made numerous public records requests in January 2019, and they offered to provide documents for over $83,000. On May 1st and 4th, 2019, I made a request, which the council denied, the school's council. And then finally, on September 11th, 2020, I paid $2,800 for documents I made through a public records request. So once I learned who was doing what, and I didn't know that before February 28th, 2018.
Can I just push back a little bit on that, because I credit that you certainly didn't know the full scope of this until then. At least we need to assume that for purposes of this case. And with regard to particular individuals, especially those at the periphery of this, you may not have known that they were involved until you got the document dump on February 2018. But a lot of the stuff on which you base these claims are things like letters to the editor that were published, or online petitions involving hundreds of people. And speaking only for myself, it starts to strain credulity that you were not aware of much of this.
Sure, I think that's crafting the complaint pro se. I added too much information about that. There was a great deal of public discussion. There was a lot of anger directed at me during this time. This wasn't about 10 people. This was about an entire town. And they were going to the supermarket, going to pick up a pizza and having people swearing at you and calling you terrible names. And this went on, and those people are not part of this case. So to know who was doing what behind the scenes.
No, but for example, when, as you allege in your complaint, Mr. Jones approached you in the restaurant and said, "We're not done with you yet," doesn't that signal that there's an organized effort out there involving more than Mr. Parsegian and Mr. Jones that perhaps you should look into?
In February 2018, those documents arrived, and I realized who the people were who were behind it. There were plenty of people like Mr. Jones who said some pretty terrible things to me. So whittling it down from 100 or hundreds of people to these 10 was not easy. And when I received the documents, I knew who was doing what, and I pursued them for 2.5 years, and they wouldn't turn them over. So there, in terms of knowing what was going on, I had a sense of who was doing things in February 2018, but I needed more emails, and they were never turned over until I paid a good deal of money for them. So this was a kind of a town-wide thing going on, lots of comments, lots of anger, and to know who was doing what. I would have had no idea that several of these people were involved in any way until years later. So,
now, I mean, why, for example, wouldn't a simple Google search have led you to the online petition?
So I was aware of the petition. I was aware of the petition, and I was aware of 3 articles that were written in one by Jenny, one by Katrina, and one by BACHE. What I didn't know until several years later is that these articles were not public opinion documents. They were written in conjunction with a football coach. They were simply retaliation. In fact, Mr. Parsegian wrote the one that Mr. Katrina published. So until I had the information, which I suspected, but I didn't know, that the football coach was up to something. Once I had the information that these were not people issuing public opinions and writing things in the paper, I didn't feel I could bring a claim until I had knowledge that the football coach was behind this, that he was the one who was providing the facts or writing the documents. And there were plenty of other people who wrote comments and did things that were opinions, that I have no evidence that the football coach was behind. But in this case, I have evidence of the documents that were online that the football coach was integral in having those published and providing his facts, and his facts were to discredit me publicly.
To
To discredit me publicly.
What if someone from the town has spoken to the football coach and happens to agree with his opinion and expresses that in an email to the board? Why is that actionable? Or expresses that in an email to the school or to school employees? Why is that actionable if it is indeed their opinion?
They weren't.
I mean, I've read through the emails.
Sure.
And at least as to some of the defendants, let's put it this way, I think a number of people would be surprised that their vocal and perhaps even unfair statements that they make in emails to school boards and to school employees could serve as the basis not only for a defamation action, but for derivative claims stemming therefrom. I'm concerned a little bit about the chilling effect that this might have.
I think it's, first of all, it's the conspiratorial element of this. It's not one person making a comment. It's all of these people doing it virtually simultaneously several months after my employment situation was public. This was not done while my employment matter was being discussed. This was several months later, right after several articles in the newspaper were published about the football coach. So this was really not commentary on me. It was retaliation because unflattering information was published.
But the retaliation was the subject of your federal court case, which was eventually resolved, as you know, through a settlement. So the retaliation aspect is...
The retaliation was employment retaliation. This was retaliation on my character.
No, I hear you, but it's just as a follow-up to Judge Neyman's question, opinions, generally speaking, are not actionable. And I mean, undoubtedly, there are a lot of people, perhaps on this bench, who think I'm an incompetent judge. I don't like that, but I can't sue them for that because they're entitled to their opinion.
There are dozens and dozens, hundreds of people who offered opinions in this case who are not part of this lawsuit. These people formulated blatant lies to discredit me with the school board at a time when the job was still open. They had kept it open. My lawyers were speaking to the school board, speaking to their lawyers about having me reinstated. And the lies that using fake names on the internet, Mr. Goldstein, not liked by students or coaches. Okay, if he had said not liked by my two children, that's a very different statement, and that's how most of these statements are. Had they been provided some context and fact, they might not be defamatory. But these individuals...
Do you question your status as a public figure for these purposes?
I do, in that the school, I was a part-time athletic director. I got paid average money. I was just a person doing my job. That would make every teacher, every person at the school a public figure. I was not considered at the level of assistant principals or other department heads. I was a part-time...
Isn't this whole debate wrapped up in what policies the town was going to adopt and enforce in terms of outside fundraising and that sort of thing? So, I mean, this was sort of a civil war in Wayland fought over these issues. And putting aside the nature of the position in charge of the athletic program, weren't you the center of the debate about these issues?
I was back in June about my employment. I certainly wasn't in July. And I think regardless, malice underlies all of this. This is just, so even if I'm a limited purpose public figure, malice overcomes that.
Well, let me test that for a second, because focusing on Mr. Jenny in particular, because his counsel will be arguing in a moment, he sent his email out in draft form first and said, I'm paraphrasing because I don't remember the exact quote, but tell me if this is 100% accurate. Isn't that the opposite of malice, that he's fact-checking to make sure he doesn't put out there something that is not true?
So Mr. Jenny had already been in communication emails with the football coach about getting his story out prior to sending that out. He's sending that email to the football coach to get his version of events. So he's providing, again, he's Mr. Parsegian's, Coach Parsegian's mouthpiece. Several days after that was published, I reached out to Mr. Jenny and said, if you'd like the facts of the case, I'd be happy to provide them, and he refused. So if Mr. Jenny actually wanted the facts, he would have taken me up on my offer. All he was doing is he was supporting his friend Scott Parsegian by being his mouthpiece and providing the facts as they were to Mr. Parsegian.
Nothing.
Mr. Cass, I'm afraid your time has expired. Thank you both. Thank you very much.
I appreciate it.
For whatever it's worth, you've done an excellent job as a pro se party.
Good morning, Your Honors. May it please the Court. Michael Pino, representing Defendant Appellee Chris Jenny. And given the number of defendants and our limited amount of time, I am going to be speaking on behalf of as many of the defendants as questions I feel
You may want to
comfortable
pull the microphone up and speak
Sure.
a little bit louder, please.
Can I just ask you how that came to be, given that your client is on the spectrum of potential culpability here toward one end of it, a fairly peripheral player in this, as best I can tell from the complaint?
Certainly, Your Honor. We've been conferring amongst us. We realized 15 minutes divided 6 ways wasn't going to get any of us very far. And, the consensus was that I would take the lead. And I have familiarized myself to the best of my abilities with the allegations against everyone and the record evidence against everyone, and I'll do my best. And in furtherance, many of the issues are common to all of us, the legal issues. And with that, I think I'd like to start with one of your questions, Justice Milkey, which is the evidence in the complaint, really, the allegations in the complaint that speak to Mr. Cass's knowledge. And I want to focus on 2 aspects of that, his actual knowledge, and then also the extent to which he knew enough to be on inquiry notice and with the exercise of reasonable diligence could have found out more. So with respect to his actual knowledge, and I'm relying solely on the allegations in his complaint, he alleges in the introduction that he was aware of hundreds of anonymous comments in online media attacking him. He's just acknowledged that he knew of an online petition signed by 460 individuals supporting the very same Wayland Public School administrators who had decided not to renew his contract. He knew of the letters to the editor that were published in the local newspaper, including the letter published by my client, Mr. Jenny, to whom Mr. Cass responded the moment it was published, noting that he had seen it and asking to speak with Mr. Jenny about it. There likewise were published letters to the editor.
Can I just ask you a detail on that?
Yes.
We know he reached out to your client the same day it was published. My recollection is there was not an express admission that he had seen the article. Is that correct?
I believe in his email requesting the meeting, Your Honor, he referenced that he was writing in connection with today's publication or today's newspaper. I can verify that, but
We know
Yeah.
sites.
also with published letters to the editor, Alan Katrina, Dennis Bache, and then Ben Downs, who Mr. Cass alleges wrote his letters using a pseudonym, but that pseudonym was unveiled in a published newspaper article in early 2016, also outside the 3-year period. So
I believe it was November 2015. It was
it may have
unveiled.
been, Your Honor. It may have been. So 4 of the defendants in this case, the defamatory statements included published, comments made in published letters to the editor. 3 of the other defendants were people who Mr. Cass knew to be antagonistic to him, and I'm referring to the football coach, the head football coach, Scott Parsegian, Clayton Jones, a defendant, and he's the one who, I believe you referenced, Justice Milkey, allegedly confronted Mr. Cass in the summer of 2015 and said, "We're not done with you yet." And also Francis Gill, who Mr. Cass also alleged confronted him in Detroit.
So I realize you do not represent Mr. Goldstein, but just using him as an example, as best as I can figure from the complaint, he was a somewhat peripheral character, even though a coach, and the knowledge, there's no evidence that that Mr. Cass was specifically aware of Mr. Goldstein's role until at least February of 2018. How do you address the argument that the public records law is fine in theory, but a lot of public officials don't always jump over hurdles to give prompt responses? And as you're thinking about that, I issued an opinion this week that dealt with a 4-year effort by a different city fighting a public records request.
So I have several responses to that, Your Honor, and you're correct. There's nothing in the complaint that alleges Mr. Cass was aware of Mr. Goldstein's email. What is in the record, though, is that he was on ample notice that literally hundreds of town residents were speaking out and signing petitions against him. That put him on inquiry notice, and if he could have, with the exercise of reasonable diligence, discovered the specific facts needed to assert these claims, he had an obligation to do so. Now, he's acknowledged in court, to his credit, that he did not even submit a public records request until 3 years after the events in question. Had he done so in the moment and had public officials dilly-dallied in responding to those record requests, we'd be having a different discussion right now. But the fact is he did not. And he doesn't get to wait 3 years knowing all of the hubbub that was breaking in Wayland at the time and not do anything to try to identify the specific speakers if, as he knew, people were making defamatory statements, or at least he alleges they were making defamatory statements. So Mr. Goldstein, to be succinct, Your Honor, falls into the reasonable diligence inquiry notice prong of the discovery rule. And Mr. Cass knew enough to dig, to investigate, and try to find out. Now, the other thing I would add, Your Honor, is there are 2 procedural paths available to Mr. Cass at the time, and he was represented by counsel. One, he could have relied on the published allegedly defamatory statements he knew about and filed an action naming the known speakers and a series of John Doe defendants, names to be provided later after he learned more about who had spoken out against him. That's one path he could have taken. Second path, and remember he was represented by counsel in the federal case, when those documents were produced in that initial federal action in discovery, he argues with the timeliness of that production, but he ultimately received them. He could have, with the benefit of his counsel, amended that complaint. That amendment would have related back to the filing of the complaint, no statute of limitations problem. He didn't do that either. So he is here really through the inaction, not only of himself, but also of his counsel in that initial federal case, and that does not save him from the consequence of the running of the statute of limitations.
Can you address the impact of the settlement agreement in the federal case on the present case?
Yes, Your Honor. Two impacts, really. First, as to the 4 defendants who were either employees, agents, or servants of the Wayland Public School System, and those would be Scott Persigian, football coach, Kerry Murtaugh, a volunteer football coach, Ben Downs, a swimming coach, and I believe it's Jennifer Goodfellow, who was appointed by Mr. Cass to serve on a cheerleading committee. Those 4, as employees, agents, or servants of the town of Wayland, would have been encompassed by the terms of the release. Now, I understand, I'm sorry, Your Honor.
Well, I think we're probably going the same direction. Are you aware of Judge Pasquale's ruling in the separate case?
I am. I am.
And why isn't Judge Pasquale correct that the last-minute insertion of the word "it's" changes everything?
I would counter your citation to Judge Pasquale with my own citation to Judge Saris of the federal court, who dealt with that issue quite specifically in her decision accepting the report and recommendation of Magistrate Judge Bohl to dismiss both of his federal actions. So as you probably recall, he filed 3 consecutive actions or simultaneous actions in February of 2021. 2 in Middlesex Superior Court, both removed to federal court, assigned to the same judge, Judge Saris, who had presided over his initial federal case. The 3rd action was in Barnstable, and that's this case. Judge Saris, in adopting Magistrate Judge Bohl's recommendation that his twin federal complaints be dismissed, dealt precisely with the wording of that settlement agreement and release. And she noted grammatically the use of the word "it's," it's a singular, as opposed to "their," which would be plural. But she also noticed that the word immediately following the "it's" was "respective." So it releases list of several inanimate entities, and then it goes on to say, "and its respective agents, employees, et cetera, using the plural and respective, as Judge Saris pointed out, typically refers back to more than just one. No need to use the word respective if what followed was only intended to refer to one of the defendants. And she also made the point that contracts need to be...
So it sounds like it's ambiguous.
No, Your Honor, she concluded otherwise, and she did so by noting that contracts are supposed to be interpreted contextually and consistent with the intent of the parties. And it didn't take her long to conclude that it was the intent of the parties to release all claims against all parties arising out of the allegations in the federal lawsuit. And I'm biased, but I think she was spot on, Your Honor. A parallel point, an accompanying point, has to do with claim preclusion. That doesn't turn on the language of the settlement agreement and release. It turns on the fact that all of the claims asserted in the 2021 cases, the 2 federal...
Would claim preclusion apply to the extent that the claims against the public officials in this case were in their personal capacity?
It would, Your Honor, because Mr. Cass has alleged a unitary conspiracy encompassing public officials and individuals and private citizens. And you can see that if you compare the conspiracy count in this case with the conspiracy count that he alleged in his twin federal actions, the first of which was against members of the Wayland School Committee, and the second of which was primarily against members of the Wayland Police Department. If you match up his allegations in those 3 conspiracy counts across all 3 actions, they are extraordinarily similar. So he's alleging a unitary conspiracy, and Magistrate Judge Bohl, adopted by Judge Saris, again, wasted no time in concluding that his conspiracy claims arose out of the same common nucleus of operative fact as the claims he asserted in his initial federal case. All of this has to do with the non-renewal of his contract, the ensuing discussion that occurred in his claims that was defamatory and caused him emotional distress and interfered with his advantageous relations and all the rest of it. Magistrate Judge Bohl common nucleus of operative facts, conspiracy, sufficient commonality of parties, claim preclusion applies, even though she, like Judge Pasquale, went off on the grammatical detour in connection with the language of the settlement agreement and release. She put that to one side and said, basically, I don't need to go there. I have claim preclusion, and that is also, in addition to the statute of limitations, sufficient basis to dismiss his claims. So I believe that takes care of the impact of the initial federal case, both the settlement agreement and the claim preclusion issues.
This obviously may not be your hunt, but I have to ask it anyway. In terms of the settlement agreement, the amount of the settlement was blacked out, and it appears that the parties to the settlement agreement consider it confidential. How is that possible under the public records law that a municipality can resolve a claim against it and keep it secret?
Your Honor, I think you're correct, not my area here, but I will point out it's not public anymore. Mr. Cass attached an unredacted copy of that settlement agreement in litigation. I believe he filed against the law firm who had represented him in the initial federal case. There was a dispute. They had a falling out after the federal case was over. He attached an unredacted copy of that settlement agreement. So the amount is out there in the public domain. Whether it should have been it right from the outset or not, I leave to others to address in another case, perhaps.
Well, for the record, we do not need to know the amount to resolve this case, so I'm not going to inquire further, but I had to ask.
I appreciate that. And then just quickly, Your Honor, on defamation, absolutely, Mr. Cass was a limited public figure, see Beck, see Gertz, which is a U.S. Supreme Court case. He did not adequately plead malice. Malice obviously is not ill will. Malice is actual knowledge of falsity at the time you make the statement. The Supreme Judicial Court addressed that.
Or reckless disregard.
Correct. The Supreme Judicial Court addressed that in the Edwards case, and said it is not enough to simply allege that someone acted with malice. You need to plead specific facts showing. And last point, Your Honor, absolutely non-actionable statements of opinion. I'm most familiar with Mr. Jennings' letter. It is replete with statements that he uses to preface his comments. It is my perspective. It is my perspective. That's classic opinion language, and for that reason, the defamation claims fail as well.
Thank you both very much. The case is submitted. That concludes the hearing with this panel. We're going to take approximately a 10-minute break, and we will reconvene with a slightly reconstituted panel.